Just testing my microphone. Can you hear me, Ian?
Yep, I can hear you fine. We'll get started in a minute. All right, good morning, Jordy, and everyone else who's joining us today for our short notice webinar. The purpose of today's webinar is, and of course the chat line is open, feel free to email, or I'll try to watch the emails, but feel free to throw your questions at us in the chat line. We are going to just focus on, it's going to be a brief or shorter webinar today, because we're going to focus on the regulation that came into place about 10 minutes after our, came public anyway, 10 minutes after our seminar, our webinar yesterday. So Jordy, the emergency order came out. We have it on our web page. If you go to our blog of yesterday, you're best to actually go there now if you want to follow us along, because we're going to just walk through those provisions and then talk about following up on our discussions yesterday in terms of what are going to be the best steps to take here. So Jordy, you're screen saving now with the actual order in council, emergency order in council there. So why don't we just, Jordy, why don't we just set out briefly the specifics of the amendments that are included, but we note that right at the start, this is a two-part, it's a concurrent order in the sense that it ties to the first video signing order, and we have to keep both in mind when we consider our counterparts situations. So Jordy, why don't we start with your comments?
Thanks, Ian. Good morning, everybody. A couple of points. As Ian, you said, it's incorporating sort of what we had before and then adding to it. So it still talks about audio-visual communication technology and the right to, basically the acknowledgement that presence of includes by audio-visual communication technology. So that's the same. But if you're going to use that, and it also requires that one of the witnesses be an LSO licensee. But the key, obviously, for this discussion is the sub 2 of this, which allows for counterpart if you're doing audio-visual communication technology or executing by that form. So it's limited to that. But it's sub 2 there, and you can see that if the will is executed with audio-visual communication technology, the signatures and subscriptions required by the Succession Law Reform Act may be made by signing or subscribing complete identical copies of the will in counterpart, which together shall constitute the will. So that's obviously the authorization for the counterpart. And then
so let's just start there, Jordy. Jordy,
yeah.
Sorry, let's just break this down in nice small bits so that we follow this carefully. So we have now the counterparts with an LSO person using the video technology, which we already know and understand, and the subscribing witnesses consigning counterparts and the identical copies of the will and counterparts. So we envision at this point in time, if this gets done, the situation is we've created our video scenario. We're going to go through this more carefully in a second, and that each individual, or if there are two witnesses together, or witness and the testator together, whatever combination thereof, will have a copy of the will itself.
That's right, a separate copy, identical. Separate
copy, but identical. All right, now a saving provision was included here, which can go to sub 3, and we can talk about that.
So when it talks about identical copies, it considers it to be identical even if there are minor non-substantive differences in format or layout between the copies. So that's what we've got, a saving grace, an escape hatch, as I've called it, just in case there's some sort of difference, page numbering is different, or the document prints on different pages or something like that. Obviously, that's open for interpretation by a court as to what are minor non-substantive differences in format or layout between the copies. How that might be extended, we don't know.
I think it's envisioned exactly what you said, though, that if you're going to send it in a PDF for people to have and print in front of them or something like that, which is probably a process that we might use, and it gets printed on someone's printer and the page numbering goes off because of the shorter pages or something like that, that's a non-substantive difference we would expect in format or layout between the copies. I don't think it's going to be much broader perceived than that, and so we deal with this a little bit in our checklist. So we've got now the core provisions for the wills. Can we just talk, Jordy, now for a minute about powers of attorney?
So a similar provision applies for powers of attorney. And so you can, the signatures required by the Substitute Decisions Act may be made by signing complete identical copies. So again, a similar provision for powers of attorney, both in our view, property and personal care.
All right, so now it's interesting that the legislation uses the counterparts term as really, essentially, I think they're using it as a term of art. And so that, before it came out, we did some research on what that means and doesn't mean. And I think it was smart of the legislature not to get, the Attorney General not to get too deep into this rabbit hole of description on counterpart. A counterpart is a counterpart, and I think we're going to find in the precedents that we've tried to draft simple language to reflect what indeed that means. But there is, of course, some room there that the counterpart language might be tortured by some analysis and interpretation. Okay, so Jordy, let's talk now through the resources that we have to make sure that a counterpart's will is done properly. And maybe if we could, for the moment, just start with just a quick overview of your because remember, we can only do this in a video environment. So we got to layer on both pieces. So let's just do a quick overview of what a video environment will starts with and how we're going to then incorporate specifically with the checklists and the precedents that we've created, how you're going to incorporate the counterparts step. So this is a counterparts will signing run through.
You would, again, have an audio visual communication technology available, so a Zoom, a Skype, or something like that, and arrange for that conference to occur and ensure that the testator and we'll use testator for now, just on a will as opposed to power of attorney, testator and the witnesses, if are all available and can use the audio visual communication technology. I think the key on this is the steps prior, as it was before, that the documents, in this case though, all three participants, let's assume they're in three different spots, okay, for now. All three participants will have an identical copy, a complete and identical copy of the document. So that really, I think, is the most important part of this whole thing, because and ensuring that it is a complete and identical copy is really very important. So I don't know if you want to address that first, or you want me to just run through the sort of process once you've assumed that it's a complete and identical copy, then.
Well, okay, so let's stop there then. I agree. Let's break it down. So the complete and identical copy is going to be one area of litigation. And just as an aside, of course, we've got to think about what we're going to do when we come out of COVID, because a lot of these wills need to be seriously revisited from a standpoint of assisting our clients. But let's presume that we want to create this valid will, and the identical copy part of this is paramount. A judge, I would expect, is going to have, and why an LSO members involved in some respect is that a judge is going to expect that the lawyer is ensuring the identical copy test is met.
Yeah.
So what are you going to do to make sure that you have the identical copy?
Okay, so dealing with that then. The way I think I'm going to do it is, first of all, I will not be sending a version that can be changed by any of the parties. So I'm going to do my best to send it in a PDF version. Yes, a PDF can be amended, but it's safer than sending, for example, a Word document, which prints out in different pages depending on the printer. So a PDF version. The other recommendation I would have is that the document contain an identifier that so that everybody can confirm they're working off the same document in case there's multiple versions or whatever else. So what we're building in for eState, and what I would recommend is that, or at least what I'm going to be using, is the idea that the footer is going to have the name of the document and the date and time to the second. Now, it's not so important what the second was or the date or time, it's that we can identify that we're all working on the one that was at 1:14:38. That's when it was generated, and ensuring that you've got all the pages. That, I think, is the first way of making sure that you're all working on the same document, or at least taking steps to try to ensure that. Obviously, you can't ensure it's identical. You can only do the best you can.
All right, so now that we've got identical and we've got the video running, what do we do next, Jordy?
Basically, you would start with the testator, just like as if you were all there together. The testator would initial all of the pages of their document. You can, we do have a checklist, and I'll just pull that up here. We're here basically that you've confirmed that the testator is, alone, and all of those other issues are to the best of your ability. And you can, I would say, if you want to go to the nth degree, you hold up the piece of page, each page, and show the page number and initial. I'm not sure I'm necessarily going to go to that extent, but have the testator initial each page, get to the last page, confirm the document again, confirm the page number. I would ask them to hold up the signing page to the camera, and then return it and sign it, and then lift it back up to the camera. And I've been asking the testator to acknowledge that is their signature. In case there's some argument that you didn't see them sign, if they lift it up and acknowledge that as their signature, I think you have that extra protection. At which point, that document is signed. Now the testator puts down their pen, and the first witness picks up their pen and starts to initial their copy of the will, and initials all of the pages, holds up the last page, and then signs on their line. And I think we're going to talk about testimonial and attestation clauses in a second, but signs on their line, again, lifts it up so everyone can see, and then the second witness would do the same. Initial all the pages, and then sign on the last page in that same sort of routine. And basically we've set that out here. And it's quite possible that the witnesses, that you may have both witnesses in one room. So that eliminates part of that. You might be signing, the two witnesses may be signing one copy if they're in the same room, right? They could do that, I think. I don't think there's an issue with that. But that's sort of how I see it proceeding.
Okay, terrific. Now let's just talk about some of the granular elements of this, and we got some great questions on the chat line. We're going to come to that in a minute. Now we've got two questions. One is the affidavit of execution, and the other is the attestation clause in this counterparts environment.
So maybe to get to that point, the idea, the will, remember the complete under the legislation, the will is together, all three copies constitute the will. So a will is not just one copy with the last pages, but in my view, I think in your view as well, Ian, but speak to me if, correct me if I'm wrong, but I think you need all three, potentially three copies of the identical document together, and they all as one are the will.
Yeah, absolutely. And that's why I want to talk about the document now first, and then we're going to talk about what do we do with the signed document. So sure. Absolutely, it's you're absolutely right, and it's clear, crystal clear in legislation. So I just think it's important that we, unlike the attestation clause with the video will and video powers of attorney, we have a little different view on the attestation clause and the will for counterparts, and of course for the consequential affidavit of execution. So the attestation clause, let's talk about our view there, Jordy.
Sure. So for those who were on our previous calls, we were debating, do we need to change that in any way? The idea is under the old order, you had three wet signatures on the same document. It looked to everybody like it had been executed in the usual fashion, and the only difference was that it had been executed, in the presence of by video conference. So we were debating whether we needed to change anything in the attestation clause. In this case, it's going to be different. It's going to be clear that this is a different situation. You're going to have potentially three copies of the same document, signatures on different pages, and that's why I think we're suggesting that we change the testimonial and attestation clause to make it clear how it was executed. And the other issue here, I think, is that you can only have a counterpart execution when it's been done by video conference. So those two factors lead us to the suggestion that maybe an attestation clause should be amended. So the other point I want to make is our legislation specifically confirms that no form of attestation is required when it's signed by witnesses. That notwithstanding that, so that's a good safeguard. But here's what we're sort of suggesting, and take it for what it is, considering we've only had about 24 hours to think about it. But I'm just going to blow that up so people can see it a little bit better. And it is on our website. So the testimonial clause, the testator signing, we've inserted by in witness whereof by audio-visual communication technology. That is, of course, the component that's required to do counterpart execution. So that's why we've put that in there. We're not necessarily, so that's really what I think what we're going to use. And then for the witness, the attestation clause, what we did here is we continued to talk about the presence of both of us by audio-visual communication technology, and identifying that we've subscribed our names as witnesses in Counterpart. And one of us is being a licensee of the Law Society of Ontario, because that, again, is required. And on its face, if somebody wants to look at this will and say, well, you know, can I determine that this is valid? Well, at least the attestation clause identifies the two key elements necessary for a counterpart execution. You're on mute, Ian. Ian, you're on mute.
Sorry, we've done one for the will in Counterpart and power of attorney in Counterpart as well. And the webpage has links to those attestation clauses. All right, so are you going to call up the?
I don't think we can get the power of attorney, any change in the power.
No, I know. Yeah. That's right.
Because it's a little different. We don't typically have that kind of attestation clause, but I think we'll put something up. We'll get something up.
Yeah, no, that's right. Okay, so now just let's deal with the affidavit of execution. And we have a precedent on that, and we've done some thinking on that. So you go ahead, Jordy. So
this is going to be a little bit unusual, right? Because the affidavit of execution is actually going to have two documents attached to it. Right, so there's going to be you're going to attach as Exhibit A, the document that was signed by the testator in your presence. And then what we're suggesting is that Exhibit B is going to be the copy of the document that you signed, you subscribed as the witness. And so for those of you who are estate planner members, the documents are in your portal already. They were there yesterday for affidavit of execution by Counterpart. And so it'll pre-populate with the client's name and all of that information. But here, for those who are looking for another version, here is what we're using. I think the first one is the one by the LSO member that says they're a licensee, that they were present and saw Exhibit A, which is the testator's copy, executed. Then they talk about Exhibit B being the one that they signed as a witness. And then we have the other one by the other, because in this case, there was some debate about, do we need two affidavits of execution? Obviously, if they're signed on different copies, so if there's three independent copies of the same document, I would think that you're going to need two affidavits of execution to explain that.
All right, terrific. Let's just spend a minute now, Jordy, just going through the chat line, because we've had some great questions. And then the first one is, when probating the counterpart's will, should all three copies be included with the application for probate? My view is yes. What is yours, Jordy?
I think it's required, because together they constitute the will. It's not a will without all three copies.
Great. We've given comment on the counterparts clause. Andy raised a good point. If one of the reasons for this idea is safety, and I can tell you that was a big policy concern from the Attorney General's office, because paper can carry the virus. Why do we recommend the copies be brought together as soon as possible? Fair question. It's just we do feel the safety issue is vital, don't get me wrong, but we're also anxious to make sure that the documents aren't floating around without some control. And so I think what we can do is, of course, wear rubber gloves and take the personal steps that we need to take to protect ourselves when it comes in. But bringing it back into the central headquarters, so to speak, is, in our view, an important risk management step. But Jordy, do you have some thoughts?
Yeah, I mean, it's not a will if they're not all together. And if one is if one is misplaced, you don't have a valid will. So it'd be like saying, you know, you keep pages 4 to 7 and I'll keep pages, you know, 1 to 3 in different places. You know, I guess if you're, so I think there's this idea that you know, you should get it together as soon as possible.
I respect the health issue, and I think that's the balancing act. And so that's a personal suggestion that you might manage it, and as we all are doing when we go shopping or receive couriers and things like that. But good question. All right, the one question was suggested: should we be inserting our LSO licensee numbers in the affidavit of execution or attestation clause, Jordy?
Sure, it doesn't hurt. I think that's fine. I mean, presumably they'll be able to determine that if there was a dispute. But yeah, no, I think that's extra and great. Yeah.
And what about the exhibit stamps? Where do they need to be? How many do they need to be applied to the back page of each of the signing pages of the 3 copies of the wills?
Yeah, so that's a good question. So the way that we've sort of thought of it is there would be on the testator's copy, it would be Exhibit A to 2 affidavits of execution. The witness 1's copy of the will would be Exhibit B to that person's affidavit, and the other witness 2's copy of the document would be Exhibit B to their affidavit of execution. So I'm not sure you'd have an affidavit of execution with 3 exhibits. You would have an affidavit of execution with 2 exhibits: the testator's copy and the witness, each of the witnesses as Exhibit B. That's, I don't know, we're trying, but that's how I see it. I'm not sure you'd have an affidavit for all 3 necessarily, because the witness doesn't technically have to see the other witness sign. Only the testator has to see that. So anyway, but I'm sure no one's gonna, well, who knows about courts, but probably putting, as long as it's the proper affidavit, and you know, do that, I guess.
And the affidavits of execution, should they be labeled A, B, and so forth?
Well, the exhibit should be. I'm not sure the affidavit. I would just have maybe the affidavit of the name of the witness if you wanted on there, but it'd be 2 separate just like it is now. I mean, yeah, I'm not sure you have to label it, but maybe that's a good idea.
All right. So the safety issue is not the paper will carry the virus. The issue is the contact between the people. I
think there was a question.
Moist. Sorry.
I think LaRue had a question about, you know, and I have this issue too. Some of my clients don't have, you know, have printers. So, you know, if you're going to do that, I guess you print a copy and courier. That does alleviate some concern that they're not signing the same document unless they have another previous version of it and that kind of thing. But, you know, so that might be possible as well.
Yeah, I mean, I envision that some of my clients, I'm just simply going to courier 3 copies out if it's 3 different, you know, some people just aren't going to have the technology or the ability to print. And that's going to be a logistics issue that I'll help them through, because, and also, as you say, bring some safety to the preparation of the documents itself. The health issue is just being raised again. Sarah, thanks. It's a question of, well, and it's interesting you say it's not that it carries on the paper, because some of the discussions I had with the ministry, some of the people there were quite concerned about it carrying on paper, but the issue, of course, is the close proximity. So, all right, now
the 2 witnesses. Yeah, just one other thing. Like for me, I have another witness available in my home, so. At that point, you may, you know, if the 2 witnesses are signing 1 copy, so the testator has 1 copy and the 2 witnesses are signing 1 copy, you might not necessarily need 2 affidavits of execution. I would do it personally, if you can. I don't think it hurts to have both, just the novelty of this whole situation, you know. But again, an affidavit of execution can occur anytime. It doesn't have to be done right away.
Terrific. All right. Well, I think we've covered our questions relating to the chat line, and we've been able to go through our precedents. Hullandhull.com, the blog went up yesterday, and estate planners got the checklists. Please feel free to use them. As we've said many times, these are our best guesses in a crazy situation. The legislation is literally less than a day old, and we're hoping that this is going to be the way to go. But having said that, we all always welcome questions and welcome any input. So today we thought we'd try to keep it short and sweet. For next week's, please send in. It'll be next Friday, unless legislation gets changed again, and there's no talk of that, I can assure you. Please feel free to, please feel free to send in your questions for next Friday's webinar, and we'll keep working through what are trying times, but in its own way, interesting and academically challenging. So thanks again, and we'll see you next week for those who want to join in.
Take care, everyone.
Thanks.